It is May 19th of 2026, and this is the Court Gallery. Today we're diving into a session where the defendants seem determined to make things worse for themselves. We start with a man whose 5-finger discount on trading cards has landed him a multi-count tour of local jails. Then, a man who's so convinced he knows best, he tries to fire his free taxpayer-funded lawyer, earning a stern lecture from the judge. And finally, we witness a defendant's bond go up in smoke after she decides the courthouse hallway is the perfect place to intimidate a witness, not realizing the cameras are rolling. Stick around. We see multiple defendants become their own worst enemy. And it all starts right now.
Good morning, sir. Are you Philip Barniak?
I am, Your Honor.
This is Judge Middleton. You're charged with retail fraud, 3rd degree, in the city of Three Rivers. It's alleged that, I don't think they put this in my, I sure miss the days when I look at the jail roster and see what was what. I'll probably be retired before I'm able to do it. It's alleged that you were at the Walmart store in Three Rivers on April 5th and did what they call a skip scan for some trading cards. They allege that you had put low dollar packs of cards together, the higher dollar packs, scan the low dollar pack, and bag both. $60 of cards. You paid $2.34. So they went through a bunch of rigmarole and identified you, and you got arrested. So the city attorney, Mr. George, is indicated he would offer time served if you pled to this charge and asked for $60 of restitution for Walmart. Having that in mind, how do you plead to that charge?
I've been guilty, sir, Your Honor.
You've been in jail since May 9th?
I've been in jail since May 3rd, 2025.
All right, but when did you up in here in Centerville? 10 days ago?
Yeah, something like that. Yes, Your Honor.
Where were you in jail previously?
Hastings, or not Hastings. I've been in I was in Kent County for like 11 and a half months. And then I just went to Hillsdale for a couple days.
All right. Well, is there anything else holding you besides this?
Just something in Indiana.
All right. Let me ask you a couple of questions. Did anybody threaten you to try to get you to plead guilty to this charge?
No, Your Honor.
Or promise anything to try to get you to plead guilty to this charge?
No, Your Honor.
You understand that by pleading to this charge, you'll be giving up your right to have a trial in front of a judge or jury. There will not be a trial.
Yes, Your Honor.
If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. But you don't have to because you have a right not to testify. And if you did not wish to testify, jury could not hold your silence in court unless the state was able to prove your guilt beyond a reasonable doubt. All right. So were you at the Walmart store way back in 2025?
Yes, Your Honor.
And did you, what kind of cards were these?
Sports cards, Your Honor.
Is that what's going on in all these jurisdictions, or this was just a Three Rivers thing?
Yeah, all the jurisdictions, Your Honor.
So how would this work? You try to get multiple packs of cards, get the valuable cards out, then sell them for money?
I would open them, Your Honor. And collect them sometimes.
All right, well, it doesn't seem worth spending a year in jail for this.
No.
I'm gonna waive the fine. I'm gonna give you 10 days jail credit, 10 days. There's $125 and $60 restitution to Myers. That's $185. That is due by 9/1 of 26. You're gonna get released from our jail and take you to the next stop.
Thank you, Your Honor.
All right. This is very compulsive behavior. Really got any treatment for any of this?
I did take treatment in Grand Rapids, Your Honor. I was in multiple classes, and I do not want to do anything evil with my hands anymore. I just want to do good. I just want to help the community.
All right. Well, you're done here at St. Joe County, so you're good to go, sir.
Thank you, Your Honor.
Thank you.
Have a good day.
I'm working on it. All right. Are you Davion Coates?
Yes, Your Honor.
Mr. Coates, you got stopped for a driving offense on April 24th, charged in Three Rivers with no valid operator's license. We get lots and lots of those. It's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. It carries 2 points plus costs. Let's take care of that one on its own merits. The prosecutors agreed to reduce that to a charge called allowing another to violate the motor vehicle code. You've been in here for a while this morning. Maybe you saw one. It's the one that doesn't carry any points, doesn't get abstracted to your license. It won't affect your ability to keep or maintain or try to get your license back. You understand?
Yes, sir.
It is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. You understand?
Yes, sir.
Now, you've executed a written waiver of your rights, acknowledging that by entering this plea, you're giving those rights up. You understand that?
Yes, sir.
Let's take a look at that. You got this ticket on April 24th at Broadway and 3rd Street in Three Rivers, near Dad's place. And they said your license was suspended at that time. It's expired is what it was. You acknowledge that? Was your license expired at that time?
No, Your Honor. I actually didn't have a license. I didn't have a license at the time. And it wasn't on 3rd Street. It was on Broadway.
Yeah, Broadway is intersects with 3rd Street. Where were you going?
I was actually going to park my truck to my sister's house because I had it at my friend's house in his yard, but he wanted me to move it because he was making his yard look ugly. So I was moving it from his house that was right there on 7th Street to Maple Crest, those apartments over there.
You probably didn't want to there either, but
I mean, my sister didn't mind it being over there in her little parking spot because she pays for a little pavilion over there in those apartments. So she didn't mind it being parked there.
All right, well, there's a $75 fine, $75 crime victims' rights fee, and $50 state minimum fee, so you owe $200.
He posted 200, I think, Judge.
Can you pay that today, or you need time to pay it?
I definitely need time to pay it. I have to find me another job.
I'm gonna give it to the end of June, about 40 days.
Yes, Your Honor.
So, do you have your license back now?
No, Your Honor, I never had a license yet. I didn't get that part. I had permits, but I haven't got a license yet.
All right, so you had it, your permit was expired, so
Yes,
you
sir.
need to renew your permit. All right, that takes care of the traffic case. Let's look at resisting obstructive case. In that case, it is alleged that on May 2nd, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Deputy Jason Van Dyken of the Sheriff's Department and Officer Gavin Flynn of the Three Rivers Police Department. They also allege that you are a third habitual offender, potentially doubling the maximum punishment to a 4-year felony offense. Prosecutors agreed to dismiss all that for a plea to attempting to resist or obstruct a police officer. Is that correct, Mr. Nossinger?
It is, Judge.
That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. You understand the charge?
Yes, Your Honor.
It would be one count. Dismiss the other count. Let's see if I can determine anything about this. All right, they went to Forest Street in Three Rivers, which is a little short street on the south end of town, to deal with a guy named Terry Frisk. Do you know who that guy is?
No, Your Honor.
All right. Anyway, there you are, and you're intoxicated. And this other guy supposedly had a gun. So, oh, wait a minute.
Yeah, Judge.
The Terry, as in the attempting to Terry Frisk a male coat. That's like kitty corner. years ago, Jeanette, the report said there was a witness kitty corner from where the accident happened. So Jeanette subpoenaed kitty corner. And the White Pigeon police were driving around trying to find kitty corner. Terry is a United States Supreme Court case that has to do with searches of a person, normally with a frisk. So, all right, they're attempting to pat you down. Supposedly there had been a gun there. And anyway, you were drunk. Tell me what happened.
Well, that was the day we all went to like my niece's funeral. She was only 12 days old when she passed.
Who was your niece?
Celeste McWaters.
Oh, yes.
So we all went back to Lacey's house, you know, just to be around like family and stuff. And I left to go to the store. But when I came back, that's when I seen all the police cars in there and stuff. So I'm basically trying to see what's going on and like how did everything escalate so quickly? Because I wasn't there when all that situation happened. I just walked up, tried to ask the officer what's going on. He roughhoused me.
Had you been drinking?
So
Had you been drinking?
I actually didn't even finish my beer. So I was drinking a little bit, but I didn't even have a whole beer.
In the old days, I could tell from the booking sheet whether they gave you an alcohol test. So you're saying you only had one beer?
Yes, not even the whole beer, like probably half of it. And they didn't.
Coach was clearly intoxicated. I better maybe watch the video of this. At any rate, so you're over there, hey, what's going on? And then you struggle with the cops where they're trying to get you to comply with their directions?
I mean, a little bit, Your Honor, because he had my arm very, like I can't describe it, but he had my arm painfully and was trying to tell me he was basically trying to move me with this arm, you know, and I'm telling him like, sir, my arm is broken, you know, you can release me and I, you know, do what you need me to do. And he studied just grabbing my arm. Then next thing I know, I'm just surrounded by three of them, telling me that I'm resisting and I need to sit down. And I'm asking, what am I being detained for? And then they saying I'm being detained for resisting. And then.
Is there a video of this?
There's Judge, I haven't received body cams.
You haven't or not?
I have not received body cams.
I don't know. Mr. Gabriel, can you tell me if there's a body cam vid on Coates?
If there's a what?
Body camera video?
Find Mr. Coates' case.
What you told me is enough for attempting to resist obstruct. I'm going to set this out about a month, and I'm going to get the police report and any body cam video.
And we'll certainly get you what we have, Your Honor.
It looks like there was a deputy there and
I know Van Dyken was there,
and so they
so
would,
he should have something.
there should be some.
Quickly. Doesn't look like it was uploaded into our system yet, as far as it's not highlighted.
Require for it. How about
Both the DVR and my BWC were activated throughout the incident, so.
say that again?
Both the DVR and the BWC, I assume that's body camera and dash cam, were activated throughout the incident.
All right,
according to
let's see if we can
Defense
get
Debacle.
copies of that.
So we'll get that to you. We don't know about the other officers, so. Officer Ritchie with Three Rivers, I'm not sure. I think he's Three Rivers. Isn't he?
Luke does, let's see who this one is. 10:30 on June 22nd work for you?
22nd. It does, yes.
Mr. Coates, what are you doing now?
Now I am currently like cutting grass and trying to come up with some money so I can start paying off my court fees in this ticket. Because I did have a job lined up, but unfortunately that day that I went to jail, I didn't get out till Wednesday, and I had a job lined up Monday for me and I couldn't go. And then when I got out and called my temp agency about it and told them the situation, they told me I was terminated. So I just been going online, filling out apps and just waiting for a phone call.
Find a job. There's jobs out. All right, I will see you on June 22nd. I'll send you the body camera video and look at it. What's going on? Your bond conditions remain in effect, including no alcohol, no assault, or threatening behavior. And you're good to go.
Thank you, Judge. Thank you, Your Honor.
Good morning. Are you Samuel Allen Vader? Oh, he's not. He's not.
I didn't know you wanted to start. Mr. Vader.
Good morning, sir. You're Samuel Vader.
Yes, sir.
You're charged with 2 counts of retail fraud in the first degree, and it appears that you're going to waive that and have the matter bound over to circuit court for a further discussion. Is that correct?
No, yes, sir.
You've got an unpaid fine for retail fraud from 2022. File 22882SN was a retail fraud. You owe $270. Do you have any money today?
Today, I can come up with a couple dollars today for sure. I get my paycheck a week from today.
Well, when it came to bonding out, you came up with $1,875. When it comes to paying your own fine and costs, you've been blowing them off for 4 years. I can put you in jail and wipe out the fine if you'd like me to do it that way.
No, sir. How much is it?
$270. You don't have to pay the whole thing, but I want you to pay something. It's interesting. When people owe fines and costs, they don't have any money. When they go to jail and they have to post a cash bond to get out, they miraculously come up with the money. I don't know if you owe money in other jurisdictions. You're from Kalamazoo, but I want you to pay this one. How much can you pay today?
I can probably pay like $100
All
or
right.
so.
All right. Your other matter is bound over to circuit court. It'll be set for a status conference sometime later this summer. And your bond conditions remain in effect. Are you still at Trimble Avenue in Kalamazoo?
No, sir. I moved to Sturgis 407 East Main Street.
All right, you're local. All right, I want you to pay on that. You're gonna pay right now, or you have to go to the ATM or something?
ATM. I really just have to go out to the car.
All right, I want you to make a payment on that today, otherwise you're good to go.
Thank you.
What do we make?
There's the counter. They're right by the stairs. Yeah. Yep, you're all good.
Come up to the podium. This is file 26822FY. You're Lonnie James Williams III, Lonnie Daniel Williams III. That's you?
Yes, sir.
And earlier this morning, you executed a waiver of
A
right to a prelim.
Yes, sir.
You got a bunch of unpaid fines, and I've been gnawing on your leg all this year. You have $1,846 worth of unpaid fines. You have an attorney pretrial on June 5th, so I'm gonna see you on that day. we're gonna talk about all your unpaid fines when I see you on June 5th on your misdemeanor case. I'd like you to try to pay on that. You've been blowing those off for some time. All right, I'll see you on June 5th.
All right, thank you.
You good to go.
The last matter I have for, on bond is Mr. Bontrager, and there was a motion to withdraw set for this morning.
So what we have left here before we get to Mr. Bontrager is only 3 cases. Garcia, Kevin McNett, is John Bush.
It's a waiver, Your Honor. He's waived and we're gonna refer him to drug treatment court.
Good morning, Mr. Wilson.
Good morning.
This is Judge Middleton. Your mother's here waiting and your lawyer, Jordan Yancey, is here. We're waiting for her to get set up in one of the conference rooms. Mr. Wilson, have you been in jail since May 2nd?
Yes, sir. Yes.
All right. Well, as soon as your lawyer logs in, put you in a private space where you can talk to her. You have extra light in there. I'm not sure it's been so dark in those. Your lawyer, Jordan Harden, has joined us here, Mr. Wilson. As I indicated, your mother's here waiting. I'm gonna put you in what's called a breakout room so you can discuss this circumstance privately with your lawyer. Good morning. How are you? I'm on the live stream. So, what have you got? A case with Judge P today? I do. There are advantages and disadvantages. We have 4 judges, 4 courts, and only 2 courtrooms. So Judge Pattis and I are sharing this, and I use it the majority of the time. As I say every time, this courthouse was built in 1899, and it was used as a courtroom until about 1975. Then it sat empty for 20 years, and they refurbished it. Yes, they did a very nice job. The county commission at that time went all in on it, and they restored all of it. Took several years. And, you know, in the old days, there was no air conditioner in here. So they didn't hold court in the summertime. We have air conditioning, we have electricity. We're all good. It is not handicap accessible very well, and it certainly is not ideal for in custody defendants. But it makes you feel like a courtroom. I'll say that.
They don't make the money they used to.
No, they sure don't. Everything now looks like a medical office. All right, thanks. All right, we return to the matter of People versus Antonio Wayne Lee Wilson. File number is 268.
I don't think he's back from the breakout room, Your Honor.
He was for a minute. Thought I saw him flash before my eyes. There he is. I hit the open button is what happened. Good morning once again, Mr. Wilson. This is file 26819 FY. Jordan Harden is with us. She had an opportunity to meet in a breakout space with the defendant. Ms. Harden, what's our circumstance here?
Thank you, Your Honor. As indicated on the record, there is a misdemeanor offer that has been tendered. That would have to be accepted under a no contest basis due to intoxication and no clear recollection. In discussing that offer with Mr. Wilson, he is willing and ready to take advantage of that and enter a plea today.
All right, Mr. Wilson, let's unpack all this. The complaint, the original complaint, alleges resisting and obstructing a police officer, Officer Anthony Fuller of Three Rivers, and domestic violence of Riley May Bales. The first charge is a felony. It's punishable by up to 2 years in prison and a fine of up to $2,000. The second count is a misdemeanor, punishable by up to 93 days in jail. The prosecutor would dismiss both of those charges if you plead no contest to attempting to resist or obstruct a police officer and aggravated domestic assault. Aggravated domestic assault is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. It usually entails the complaining witness seeking medical attention. In this case, it appears the complainant had a broken nose, which would be qualified for aggravated domestic assault. The other felony charge would be dismissed. Do you understand?
Yes.
All right, well, let's also talk for a minute about pleading no contest. When you plead no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. One of the reasons for no contest, probably the most common reason, is that you're intoxicated. You don't have a clear recollection of what happened. That would be a basis for pleading no contest. But if you do plead no contest, I would set the matter for sentencing and there would be a conviction, just as though you pled guilty or were convicted at a jury or a bench trial. Do you understand?
Yes.
All right. Do you understand that if you do plead no contest to this, you'll be giving up your right to have a trial? We will not hold a trial on this matter. Do you understand?
Yes. Yeah.
If you have a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. Excuse me, I'm trying not to sneeze. If you had a trial, you'd have a right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes. Yes.
All right, and you plead no contest
Yes.
to aggravated domestic assault and attempted R&O. Is that correct?
Yes.
I'm going to use the bond information report that was filed with the complaint. It says officers were dispatched to assault in progress, 206 River Drive 1. Is that the apartments across the street from the dairy bar?
Yes.
I observed many familiar faces in the parking lot. So was this at Edgewater Apartments? Or Edgewater, all right. Riley Bales was holding her hand and bleeding. I wanted to speak to her. Riley said her ex-boyfriend, Antonio Wilson, had slapped her with an open hand in the hallway. She hit him back and they both fell down the steps. Antonio continued to fight with each other till the neighbor called the police. Riley went to grab her Xbox and Antonio assaulted her by using her feet on her right hand. Her fingers were bleeding. She was also hit in the face and believed to have a broken nose. When Antonio Wilson was confronted, he said, whatever Riley said is what happened. He was detained and he spit in Sergeant Fuller's face. Well, that certainly consists of attempted R&O. You were out on bond already, and you were not to have any contact with Alicia Sanchez Wilson. who was also in the parking lot with you. You were .208. Spitting in the face is a quintessential injury and offense, and it is sufficient for resisting obstructing a police officer. I'm going to set this for sentence. I need victim input and police report. What were you doing before you got locked up? Did you work someplace?
No.
Have you ever had a job?
Not since my accident. Well, yes, I worked at Applebee's.
When was your accident?
I worked at Applebee's.
When were you in an accident?
In 2025, I think.
And that's limited your ability to work? I don't think you're doing yourself any good by drinking as much as you are. I think you got some residual injuries from that accident and you're compromising your cognition by drinking 2.5 times the legal limit. How old are you?
22.
All right, let's find a date that works for your lawyer. Jordan, you're here on June 1st. How about if we set this for sentencing for 10:30 a.m. on June 1st?
That works, Your Honor.
All right,
believe-
Mr. Will.
I believe Mr. Wilson was set for a bond violation hearing this morning on that other case with Judge Pattison.
I don't know if it was in front of Judge P or me
I
or.
believe it was Judge Pattison. He's got Mr. Gibson on that file. I only bring that up because Mr. Wilson inquired about bond in that case. I'm not sure if it was reinstated. I've not heard back from Mr. Gibson. But is the court touching this bond at all, or if he posts it, is he?
No, in fact, I'm inclined to cancel it. But I'm gonna leave it where it is at 3,000 cash.
Thank you.
All right, Mr. Wilson, I'm gonna get more information. Jordan, what do you know about the accident?
He did not bring that up to me, when we met, so that was the first I was hearing of it, but I'm happy to, his mother is here, see if she can give me
Yes,
some
his
information
mother
on
is
that.
here. So have you got information regarding his treatment from the accident?
He had severe head trauma.
Yes.
Brain split. He was in the accident June 21st of last year. It's almost been a year. And they're finding out that he has memory loss, blackout. And we got a bunch of questions.
Well, I'd like you to share that information with his lawyer. I can tell just by talking with him that he's different than when I talked with him before. And he should not be drinking like he is. He broke this girl's nose. He was violating his no contact provision. He's out drinking with a bunch of kids that are not a good influence. So he's going to stay where he is probably until June 2nd.
June 1st, Your Honor.
June 1st. At 10:30 a.m. All right. We'll see you then and we'll get more information.
The last matter I have for, on bond is Mr. Bontrager, and there was a motion to withdraw set for this morning.
So what we have left here before we get to Mr. Bontrager. Good morning, sir. Are you Mark Andrew Bontrager?
Yes,
Let me pull your case up. I'm Judge Middleton. I don't know if we met before. You're charged in a felony complaint that alleges that you did to resist or obstruct Deputy Keenan Morrill of the Sheriff's Department. Resisting and obstructing the police officer used to be a misdemeanor, but now it's a felony. It's punishable by up to 2 years in prison and a fine of up to $2,000. They also allege that you failed to report an accident to fixtures. A fixture is something along the side of the road, like a fence post or a sign post or a rock or something. That's a misdemeanor. It carries no points. It's punishable by up to 90 days in jail and a fine of up to $100. The case that get you here is the felony resisting obstructing charge. Jordan Harden is here, and she has filed a motion of withdrawal as your attorney. Ms. Harden, you wish to speak to that?
Briefly, Your Honor, as indicated in my motion, Mr. Bontrager has expressed to not only my staff, but the clerks that he plans to represent himself on this matter. In my staff's attempt to assist him with paperwork that he had demanded from the clerks that morning, I instructed my staff to contact him to advise him we were still waiting on that discovery from the prosecution, but would provide it as soon as it was available. Mr. Bontrager was agitated on the phone with my staff, was demeaning to my staff. It's not something I tolerate. At that time, he also made indications to my staff that he was going to represent himself. So at this time, I don't think the court can compel him to utilize court-appointed counsel. He wants to represent himself. I'd ask the court to allow him the opportunity to do that and remove me from this case.
All right, Mr. Bontrager, what's your position here? Do you want to represent yourself, or would you like me to have an attorney to represent you?
I've chosen to represent myself.
All right, tell me a little bit about that. According to Ms. Harden, now we appointed an attorney for you. This is a felony. And it could result in a prison sentence. Very unlikely you'd ever go to prison on a 2-year offense, but it's a felony and it carries a maximum punishment of 2 years. So we routinely would appoint an attorney to make sure that you have one. At our expense, the taxpayers are paying for your lawyer. She says that you were abusive to her and her staff. And she's right. I don't need to put up with that. And so she would ask to withdraw, which I'm inclined to grant. The question would be, do I appoint somebody else, or do I allow you to represent yourself? The night you got booked, you wouldn't sign the booking sheet. I don't think you really agree with all of our system. Are you on probation, parole, or bond anywhere?
Well, I suppose I have it on probation or something.
Where are you on probation?
I'm not on probation. I
Okay.
mean, it's just, I don't know what to call it, I guess.
What's your occupation?
Self-employed,
Doing what?
handyman.
You don't really have, there's more than one Mark Bontrager. It's a fairly common name, but you're Mark Andrew. All I see is you got a seatbelt ticket that you paid. I don't see any criminal history here. Now, what was set for today is called a pre-exam conference, because when you're charged with a felony, the matter is set for a preliminary examination. That's set for next Tuesday at 1 o'clock. A preliminary examination is a hearing where it must be established that there's probable cause to believe a crime was committed and probable cause that you did it. You don't get found guilty or not guilty at a preliminary examination. The prosecutor would present evidence to try to show those two probable cause things. Your attorney would be there to make sure that the prosecutor is complying with the rules of evidence and procedure. Your attorney would have the right to cross-examine witnesses, argue on your behalf. If you're waiving your right to an attorney, you give that up and you're going to do it yourself. That's what you want to do? Do you want me to appoint another lawyer for you? Are you considering it, or you just don't want to answer the question?
I believe to represent himself.
How far did you go in school?
8th grade.
Did you come from an Amish background? Are you still in the church or are you outside?
We left the Amish.
All right. You're past Rome Spring. They just left the community?
Yes.
There is a saying that it's a fool that has himself for his own attorney. Even if you're an attorney, you're foolish to represent yourself. There's an undercurrent here of anger and discord about the whole process. And I'm not unwilling to let you represent yourself, but you're swimming in real deep water. You need to know the rules of evidence, the rules of procedure. The prosecutor's going to present evidence to find probable cause that a crime was committed, and the matter's going to be bound over to circuit court. Then you're really swimming in deep water. You'd have a jury, you'd have to know about jury instructions, rules of evidence, rules of procedure. But if you want to represent yourself, I'll set it for a prelim for next Tuesday at 1 o'clock. And they can present evidence to try to show that there's probable cause. If you do want to have a lawyer, I'll appoint a new lawyer. But if you treat him like you treated Lawyer Harden, I'm going to cancel your bond. You sit in jail while this case ends. We're using taxpayer money to hire a lawyer for you. They're not your slave. They are your lawyer. They're professional people that are hired by the county to represent people in criminal matters, and they do it all the time. And I don't want you abusing them or their staff. So
Can evidence be presented of that?
say that again.
Can evidence of that be presented?
Evidence of that you abuse their staff.
Sure.
Well, I'm not making a finding of contempt or anything. I'm just releasing her. If you do it again, I'll have a hearing that it happened. Once you treat your lawyer with respect, they don't instantly snap their fingers and get all the evidence. You heard in the other case, there's body cam videos. We don't have it yet. Frankly, they should have had it. They should have had it before he agreed on the plea, but at any rate, we're going to get it. Have you seen any? We haven't seen anything. So
I did advise him before we went on the record that if he were to represent himself, it would be his duty to reach out to the prosecution to file any necessary discovery motions. However, I did let him know that our prosecuting attorney is very good about getting evidence to us as soon as they have it. So, but I did let him know that that's now going to be his responsibility to do so.
So is the opportunity of presenting evidence that I have.
yes, you have an absolute right to present your own evidence. If you have a bystander that videotaped it, or if you have 6 people that were standing there watching this go down, you could subpoena them to testify on your behalf. You have an absolute right to present your own evidence. You also have a right to testify. Get up and tell your side of the story under oath. You don't have to do that. You have a right not to testify. And if you don't want to testify, they can't hold your silence against you. But you do have a right to tell your side of the story.
With an attorney.
Would you like an attorney? All right, I'm going to appoint new counsel. I'm gonna reset PEC for 6:19, no, 6:26 at 8:30. I think that's the wiser course. I would really rather you had a lawyer. And the prelim would be June. Wait a minute, 5/26/26 at 8:30. And the prelim was needed for June 2nd at 1. All right, Attorney Harden is released. All right, give your lawyer the benefit of the doubt. They're not out to get you. They're out to try to help you work through this. I don't know much about what happened. In the other case, I don't know much about what happened, so I'm gonna watch the video, but he pled guilty. I don't have the right to do that. If you haven't entered a plea, I'm not supposed to know the facts. So Ms. Harden, your obligation is released. I want you to take Mr. Bontrager out. He'll get a notice. He'll get a new attorney appointed to represent him. So either me or Judge Patterson will see you next Tuesday right here at 8:30. You're good to go, sir. Thank you.
The 26th.
The 26th.
Court does call the case, People versus Cameron Larry.
CP. Morning, Your Honor. Return Assistant Prosecuting Attorney on something.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Larry. Mr. Larry, could you state your name?
Cameron Larry.
What are we doing?
All right, put that up.
Yes. All right, record should reflect we've had a bench conference in this case. I'll pass this matter.
Your Honor.
Thank you, Your Honor.
Court calls the case, People versus Cameron Larry.
Good afternoon, Your Honor. Return Assistant Prosecuting Attorney on behalf.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Larry. Mr. Larry, could you please state your name for the court?
Cameron Larry.
What are we doing?
Your Honor, as I explained at the bench, people are seeking an adjournment. Quite a few things have come up. The evening with the, and I mentioned is that the officer in charge is informed me at the point that he's ill. They're not here to testify. We would need his testimony here today. Your Honor, there's also the issue of the jail calls that were made. This defendant, while he was in custody, called the victim multiple times. The content of those calls are highly concerning to the people. They suggest witness tampering. The fact that she is not here today kind of completes the concern we had that his calls and his communication with her have had the effect that he intended them to have. Specifically, we have concerns because he gave her a story of what to come and tell the prosecutor's office. She did comply with that, and as counsel is aware, and court is now aware, she has indicated to us what I would call a recantation, but certainly a different version of events matching what this defendant instructed her to do. There's a lot more to it, including statements he made, telling people that the victim is not coming to work and so on. With all of that, Your Honor, we have concerns, so we need to further look into that. Those calls were shared with the public defenders already. I resent the very specific call to defense counsel this morning. I'm going to be listening to those a little more closely. I'm considering witness tampering charges moving forward. And we do have concerns about this defendant being out of custody and the behavior he might have engaged in and may continue to engage in, and making sure the victim does not appear to testify against.
Mr. Warren.
With respect to the people's adjournment request, at this time, we have no objection to that.
Okay.
And I had an opportunity to speak with my client, Mr. Larry, and Mr. Larry Sr., who is present in court today. Miss Larry was here earlier, and both of his parents really have been calling off work, making every effort to be at all of their sons' court dates. I
I recall that the last time he was here, they were here. I recall that. Okay.
And in addition to that, I know back on April 27th, Miss Larry wrote a character letter to the court, which I know the court can't consider at this juncture. However, that was sent to counsel, and I reviewed that. And Miss Larry speaks highly of her son. And I think, insofar as Mr. Larry's at a fork in the road, they are committed to make sure he takes the right path and comes out of this continuing the positive work he was doing before arrest in this case. And I would note that this is Mr. Larry's first interaction with the criminal justice system, as far as I can see on his criminal history. When he was released from custody after spending about 30 days in jail, he was placed on home confinement and lives at home with both of his parents. During the time he was in custody, he had to deal with the consequences of being in custody, which included losing his job. His parents want him to get a new job, and I talked to Mr. Larry about essentially scheduling an interview, talking to his tether agent, and seeing if there can be an accommodation made for him to go and do an interview, which I know, if that needs to be done by stipulation or order, I know it's something that has been accommodated in the past. Mr. Larry's enrolling in school. He's Washtenaw County Community College for either CDL, HVAC licensure, but he's trying to get higher education. And I think since he's been out on home confinement, he's certainly not been violating the court's orders.
Well, but the problem is I don't know that. That's my great difficulty.
When I talked to Mr. Larry's parents, I was very specific about what the court's orders are, including no contact and what no contact means. They ensured me that they're not going to let it happen under their roof. And as far as he's on home confinement, I mean, what they relayed to me is essentially the court's home confinement tether at this point is he'd be on home confinement anyway. They're making sure that he's staying on the right path. They don't want him to end up in jail or at the end of this case to be worse off than he was coming into it. So I'm going to ask the court respectfully to consider continuing his bond at this time. Come back on the next date. I've already talked to Ms. Tana about resolving this case. I'm going to talk to my client at length about resolving this case, which, what we pondered does entail further court supervision. But as far as abiding by the court's orders, Mr. Larry and his parents are going to make sure that continues on.
My difficulty is that I believe that his parents have all the best intentions of the world and are probably the most disappointed by all of this. But I myself am very disappointed when I find as I told you, counsel at the bench, I gave him a huge break the last time in letting him out, knowing that there were phone calls. That's come back in certain respects to bite me because I now know that these weren't just, not to minimize them necessarily, but not just context to the alleged victim saying whatever. He was to manipulate the system. I don't even know what's going through his head. Scared. Well, he should be, because he's got me right now. He should be scared. Because the grand reality of it is that I can't trust you to be out. I don't know what you're doing. Understand what I have here. I let you out. I gave you the opportunity. You create some story that the victim, no. Because you want to believe in him, that's fine. I want to believe in him too. I gave him an opportunity and he has messed this up and is now facing potentially another felon. And I don't know that you even understand that, young man. No, you don't. Why would you put yourself in a position to pick up another felon? You weren't even supposed to be communicating with this person at all. But then you communicate and you go even further to concoct some story and now and here's what you have to understand from that. From that, you concoct that story, and then I have no victim here today. She not only takes the story that you give her, communicates it to authorities, then doesn't show.
Your Honor.
Go ahead if you think it's advisable to say something to me, because I am livid right now.
Takes me on the phone. What was she? Agreed. Tell me. Your Honor, I would ask the court to consider the fact, since Mr. Larry's been released on home confinement, I think almost right away, he got into some level of domestic violence programming. I spoke with Ms. Tana. There's a program that we are both familiar with that I want to refer him to immediately. And to addressing, the underlying allegations here, it addresses those of issues in terms of, it was a bond violation trying to impact the outcome of proceedings, those kinds of things. And I want to make sure that, Mr. Larry's getting to the resources he needs. I think if he's at home on home confinement with his parents, I think he's in a better.
How do I know he's not contacting the victim?
Well, when I spoke to his parents, Your Honor, they advised.
I don't doubt that they're going to do the best they can. I trust them. I don't trust him.
Mr. Warren Green, the kind of choices is available in jail if he wants to start that. Might be advised.
Your Honor, my client would just assure the court he's not going to violate any court orders, including the no contact
He
order.
assured the magistrate of that after his arraignment.
Understood. I was nervous and she was pregnant, so this is my first time, Your Honor.
What?
Your Honor, I think my client's expressing that it is his first interaction with the justice system. He was nervous about the ultimate outcome of this case. It's a big.
What confusion do you have of do not contact this person?
I don't think it's confusion, Your Honor. He admits to violating the court's orders with respect to the no contact order. I think it's naivety, and I think it's him trying to change the outcome of this case. I understand that as far as it's a bond violation. I'm not sure if it rises to a matter where we're dealing with forfeiture by wrongdoing at this point. So I don't want to go too far down that road in terms of what I address, but he knows that's a possibility at this point. And at this point, we're kind of shifting gears and talking to the people about a resolution that involves significant domestic violence programming.
And for the record, if I may, at least 38 calls were made to the victim using other inmates' pins. So being naive, that to me doesn't indicate a naive person. That is deliberately working to kind of fight the system, trying to get out of it. And I agree, trying to affect the outcome of this case. And that's exactly what we're trying to prevent.
And see, it's that behavior why I can't trust you.
Stay here.
Because I don't have a doubt your parents are going to put everything they can possibly put in place to try to make sure you don't mess this whole thing up. But we do the same thing in the jail by giving you a PIN number. And what do? You try to circumvent and go around that whole thing. Then you try to concoct some story, and that comes back, and now you're going to potentially face another felony, as well as proceed without the victim on this case. You don't even begin to understand what the heck you've done. And if you had just stuck by the rules, we wouldn't even be in this boat. I don't need to have this conversation with you. I don't need to try to make sure that the victim in this case can proceed with this case if that's what she so chooses to do.
Okay. 30 days. What that I did. So already mistakes were already made. I was 30 days sitting there.
Your Honor, I'd ask the court to consider that the time Mr. Larry spent in custody did have an impact on him. And moving forward, if the court is gracious enough to consider continuing his bond at this point, if he's going to comply with any of the court's orders, but that's going to be a constant reminder as to what happens when he does not. And, I referenced naivety earlier. He didn't think he was going to get caught, and he did. And I think he knows at this point, and his parents well know at this point, if he's caught in violation of his bond conditions whatsoever, he's on thin ice, and it's going to land him back in jail. If it does,
I don't know if he cares, Mr. Warren. I really don't know if he cares. Because if he had cared, he would not have done what he did.
Your Honor, he's been working on himself a lot. This arrest, hopefully in the long run, going to be the biggest turning point in his life. And that's his sentiment he's expressed to me this whole time. He's got two people that really care about him, that are really going to make sure that he stays on the right track if the court's gracious enough to continue his bond at this point.
The bond that was posted for you was not your money, was it?
No, sir.
It was your parents' money.
My brother and my sister.
Then you got your family here. Everybody's trying to do everything for you except you. Here's what the problem is, counsel. I've got to figure out, and I've got to give the people time to figure out why this victim isn't here. But until such time, do you know how long it may take people to figure out if they're going to bring additional charges against him?
Your Honor, I have no problem reviewing it today. I do need the OIC to do some. So I would ask for it.
I'll adjourn the preliminary exam to May 26, 2026, 9 a.m. before me. That's in person. At this point in time, man, you got to understand, you make your bed, you got to lie in. I'm not going to, don't look at me like this is you. Your family put up their money. They did that. Your parents are down here with all their time and everything, trying to stand up for you. And you did this.
Before I already made the mistakes, Your Honor. It was way before that. After I got put in there for 30.
Here's the problem. You've interfered with the whole system. That's the problem. You should have never done any of this. Ever. So if the people would do that, review it, get in touch with counsel, but this time I'm going to revoke his bond. Defendant's remanded. I will consider his release if the people can figure out exactly where they're going to go with this and have the OIC. I'd ask them to hurry up and do it. I don't want to leave him in jail, but he's made his bed and that's where he is now. But I got to figure out that everybody else in this whole system is safe, not just you. You can take it. Dad, don't do it.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Patrick Rowe.
And Alex Warren Green on behalf of Mr. Rowe. Mr. Rowe, could you state your name for the court?
Patrick James Rowe.
Your Honor, before me are two preliminary examination waivers. Mr. Rowe is going to execute those at this time, and I believe waive through a preliminary examination.
I'll change my mind.
May I speak with Mr. Rowe?
Here.
With the accommodate passing, Mr. Rowe.
I'll just waive it. I'll just
Bite your day. No, go.
Okay.
Get back.
Thank you, Your Honor.
Sure.
Thank you.
Court recalls the cases of the People versus Rowe.
What's your difference?
And Alex Warren Green on behalf of Mr. Rowe. Mr. Rowe, could you state your name?
Patrick James Rowe.
Your Honor, I appreciate the court's accommodation. I had an opportunity to speak with Mr. Rowe, answer a couple questions he had. At this time, I do believe he wishes to waive both of the preliminary examinations in both cases. We are.
Is that a correct statement, sir? You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also weigh their right in both of these matters. Preliminary examination having been waived, defendants bound but on a single count in each case.
Your Honor, we acknowledge receipt of the information, waive any further reading, and stand mute.
Defendant having waived formal reading, stand. Court will enter not guilty plea. Pretrial will be set for
Court at 1:30 for Judge Slade.
June 4th, 2026, 1:30 before Judge Slay.
Your Honor, if I may briefly address bond.
You know, you can, Mr. Warren Green, and I know that the passing of this was not your fault. I could see, I guess people don't think that judges can see. I saw what the defendant was doing when he came out here and the whole hiccup that happened, because he was looking around the room, seeing whether or not there were any witnesses or anything like that. And then he was going to try to change your mind and throw you under the bus for saying that there was going to be some type of waiver in this case when he was just playing a game. But you can go ahead with your bond argument.
Your Honor, as part of this waiver that I negotiated with Ms. Woods in this case, we are going to be referring Mr. Rowe to the recovery court. He's going to be screened, and I think that is ultimately a good landing spot for Mr. Rowe. In speaking with Mr. Rowe, I would ask the court to consider converting bond to a personal bond. He was taken into custody and is currently held on a $25,000 bond in the case ending 1337 and a $1,000 10% bond in the case ending 0407. That arose after essentially going to community corrections right after he was released in March, not being able to provide a sample, and then no further contact was. But since that time, Mr. Rowe does have stable housing in the area. He provided me an address in Ypsilanti. He could live there with a friend who I believe was also a former colleague. He's seeking reemployment right now in the food service industry and wants to eventually go to technical school. He graduated high school in 2016. He provided me updated contact information, which I could pass along to community corrections. But, Mr. Rowe is focused on maintaining sobriety and getting the treatment he needs to sustain that.
Understood. Probably the first step in sobriety is some honesty, not playing games. Response.
Judge, if the court is inclined to lower his bond and allow him to be released, we'd ask for at least some sort of GPS tracking device, Judge, based on his failures to appear and drug testing.
But we haven't gotten through the process yet of him going into a sobriety court.
Not yet, Your Honor. There are referrals being made, right?
Well,
Or if the judge being
And I-
inclined to release him to treatment. I don't know if that might be a better option.
well, I think what I'm going to do is I'm going to leave his bond where it is. Judge Slay has a treatment court, certainly, and he can try to get through there, and she more than adequately can monitor the release of this defendant. Motion for a reduction in bond is denied.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Thomas Fasher, Tuesdays.
Motion for retrial on behalf of Mr. Vassar in case ending 1002.
And Assistant Public Defender Ben Dunawith on behalf of Mr. Basher in the case ending in 5772. Sir, would you please state your name for the record?
Thomas Fasher. Thank you. What are we doing?
In 1002, it's my understanding that people are not able to move forward in that case. And based on that, I would be asking for a bond motion, a brief bond motion, Your Honor.
Your Honor, it's correct that we cannot proceed with the felony counts. We'd ask for a remand to district court on this.
That's nice.
So you cannot proceed on counts 1 and 2 and would remand on 3.
That's correct, Your Honor.
Granted dismissal on counts 1 and continue the defendant's not guilty plea to count 3. Pretrial in this matter will be set
June 1st at 9 a.m.
June 1st, 2026, 9 a.m. before Judge Washington, excuse me.
I'm sorry, Your Honor, I'm sorry.
June 1st, 9 a.m. before Judge Washington.
Thank you, Your Honor.
As the bond.
Your Honor, in this case, I believe the defendant's bond is $1,000, 10%. The people have not been able to proceed on counts 1 and 2. We would be asking for a personal Ricardo's bond. The defendant's guardian is here and has expressed to me that she would be working to making sure that he abides by all terms of his bond and that help him secure housing in this matter. So therefore, we'll be asking for a PR bond, Your Honor.
Your Honor, we're going to leave it to the court's discretion with any case involving domestic violence. We do have, of course, concerns. Who's not present here today. But understanding is being remanded.
And I'm not opposed to necessarily changing the bond, but he'd have to be interviewed by probation prior to the court doing that. So you can bring that before Judge Washington. I'm going to continue his bond at this time.
All right, thank you, Your Honor.
Your Honor, the case ending in 5772, we do have a plea.
Plea form in this case indicates that the defendant will be pleading to an added count 3 of larceny less than $200 to 93-day offense. Lesser plea to that added count 3, counts 1 and 2 would be dismissed. Defendant agrees to pay full restitution on all counts. Court's full understanding.
That is correct, Your Honor.
I have him. Oh, want to say something, sir?
Yeah, I was gonna ask you if at all possible, can I get my privileges back so I can call my family?
We got to deal with the plea, then we can address that stuff afterwards. It's just one thing at a time.
I have him sworn.
Right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so be God. State your name, please.
Thomas Van.
Sir, it is this court's understanding you're going to plead guilty to an added count 3 of larceny less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. $100, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking the plea, I would not be your sentencing judge, and you would be sentenced before Judge.
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead? You understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy there. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Go on probation or parole?
It's this case.
No? No. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
Oh, yeah.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will because you believe that you are indeed guilty?
Yes, Your Honor.
May 9th, 2025, at the location of 3035 Washington Avenue, City of Ann Arbor, Washington County, State of Michigan. What'd you do at the Verizon wireless store that makes you think that you're guilty?
I took a watch off the wall, charging cable.
Took a what?
A watch off the wall and a charging cable. I asked if I could use charging cable, and I left the building with it, and then brought it back to him. I just proved to somebody that I could take it from him and give it back to him. It was basically like a YouTube hoax, but he got it back.
Can I ask a question, Your Honor?
Took it out of the store, and then brought it back. So when you initially took it and left the store, were you intending on taking it and keeps? No. Can't take his plea? I don't have the requisite intent for a larceny. So we're
gonna schedule this for exam again.
I don't get it. What was that?
Are we ready to stay, or did you please quit? Got it. I understand it.
Watch and just
No, I was
all right.
No, I was stealing the watch.
Right. He gave the
I was stealing the watch. I gave him his cable back.
Yeah, so the watch is
The watch was
the
stolen.
value.
Yeah, the watch was stolen. I was stealing the watch. I gave him his cable back. I was proving to do that I could get his cable.
That's not what he just said, though.
Yes. I was proving to do that I could get his cable. And I wasn't talking about the watch. I was talking about the cable. Because the cable is what I proved that I could get his cable off of his neck. Because he had his cable, his charging cable I got off his neck, the dude at the Verizon wireless store. He had the charging cable around his neck.
So, sir, no, I'm not, this is not.
He got the charging, he had the charging cable around his neck.
Mr. Bash,
I pulled the.
what did I just say?
Okay, I pulled the watch off.
What did I just say? I'm not taking your plea. I'll put it out a week, talk about it, come back, and if there can be a clean plea, I'll deal with it then.
Okay.
But I'm not going to do it this way.
Same one, I'll say the same thing next time.
Your Honor, Mr. Vasher briefly mentioned his phone.
Yes, hang on.
Okay.
Preliminary examination in the 15th District Court matter. I'll reset it to next week, the 26th. To May 26th, 2026, 9 a.m. before me. Yes, Mr. Creature, I don't have that file anymore.
Oh, I'm sorry, Your Honor.
Next week you'll have 89. Go ahead.
It's my understanding that Mr. Vasher does not have phone privileges. He needs to make arrangements with his guardian upon his release for housing, and his guardian needs contact with him so she can arrange that. That's why we're asking for phone privileges back, at least to speak to your guardian. Is that correct? And
Yes, Your Honor.
and so she needs to be able to talk to him to arrange housing and things of that nature, make sure he's doing okay.
Go ahead. Anything from the people.
I'm gonna use it for discretion. This is in person. This has been one of my experiences very well. And that guardian is who approached us had not spoken to police about the domestic violence case, seemingly been the victim of that case. So I had concerns about there being contact with Basher and his sister, who's the guardian, given her contact with the victim of the case.
I would have the same concerns. I'm not going to change anything. That after he's interviewed, then I think all of that can be addressed.
Okay.
Great. Thank you.
Thank you. Probation. Or 10. Oh.
We have probation.
All right. Thanks.
Set up a no contest.
All right.
Court calls case, People versus Debbie and Morgan.
Good afternoon, Your Honor. Justin Zaid, appearing on behalf of Davion Morgan. Say your name.
Devion Morgan.
Your Honor, date and time set for an exam. I apprise my client of rights with respect to holding a preliminary exam prepared to waive that should have an executed waiver form.
Is all of that correct?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by
Yes.
probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
All right. You understand you'll not have that hearing and you'll proceed to circuit.
Yes, Your Honor.
All right. People also waive their in.
Yes, Your Honor, there was an offer. If I may put that on the record as
Yes, go ahead.
Seek to add additional counts of larceny 1 to 20,000 or larceny less than 200 as relates to this case.
Is that a correct statement?
That's correct, Your Honor.
Preliminary examination having been waived, defendants bound over on the single count. Counsel, you acknowledge receipt of the information.
Yes, Your Honor.
Client stands mute.
Correct.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
July 15th at 1:30 with Judge Conlon.
July 15, 2026, 1:30 before Judge Conlon.
Understood. Thank you very much, Your Honor.
Thank you.
You may.
I became aware this morning of altercation or altercation is the correct word that occurred out in the hallway in the court with the defendant and one of the people's witnesses. The defendant called the witness numerous derogatory terms. I have audio as well as a video that I can show to defense counsel if he wishes to examine and observe that himself. But I'm concerned about the statements that the defendant was making to that witness, especially in anticipation of the possible exam of the morning. I have asked Detective Quinn to prepare a supplemental report with the formal statement to see if additional charges for witness intimidation may be appropriate based off of what was stated. But at this point, I'm looking at the bond to be revoked.
Mr. Allen.
Your Honor, I have not been. What? I have not been presented with any of that information to either confirm its accuracy or corroborate any of the statements that Mr. Cook made. I think that it's certainly premature to make that request until the court has an opportunity to inspect it as well as myself.
Well, we're going to get the opportunity now because if you come into a courthouse intimidating like that, that's not here, not going to happen. You could take the defendant back, Mr. Allen, hold him in a cell, get that documentation to counsel, have him look at it, and I'll hear argument on it later.
Let's go.
Court does call the case of the People versus Devion.
Good afternoon again, Your Honor, Reigns, the people.
Good afternoon, Your Honor. Justin Zaid, appearing on behalf of Davion Morgan City.
Yep, I'm working.
Okay. All right. Where are we on this?
Your Honor, I've had an opportunity to show defense counsel the video as well as audio that I referenced previously to the court's my understanding that we are having a hearing on this bond violation. I do have the witness present and ready to begin whenever the court wants.
That's correct. We're ready to proceed.
All right, go ahead. I'm ready.
Call Stephanie Sinks.
And please come forward and be sworn.
Sure. First name is Stephanie, Stefanie. Last is Sinks, S as in Sam, INKS.
Oh. All right, thank you. Main quiet.
Good afternoon, Stephanie. How are you doing? Stephanie, how are you involved with this case?
I am the guardian for Mr. Escobar.
And that's the named individual on the complaint, is that correct? Where were you this morning at about 10:50 a.m.?
Stay outside of the courtroom.
Where outside the courtroom?
Go out these doors. I'm on the bench on the left.
Was anyone else out there with you?
Yes, one of the other witnesses, her first name is Diane.
Where was Diane seated?
She was sitting, and I'm facing out the window. She was on my right side.
Was anyone else in the hallway with you? Or not with you, but was there anyone else in the hallway at that time? Who?
The suspect was sitting on the bench right of the doors with some other people that I noted there.
When you say the suspect, who are you referring to?
And beyond Morgan, I'm Morgan.
Can you please point to that individual and identify them by an article of clothing that they're wearing?
In the white shirt, I think it's got a nice. No, I can't see it.
All right.
The record may reflect this witness as identified the defendant.
Records shall so reflect without objection.
Who was the defendant?
Making verbal comments in my direction.
What sort of verbal comments?
Started off, I believe it was a skinny ass cracker. And then went on to a number of other things, making comments about a bitch and a hoe, and that I wasn't going to get away with this. The gist of it was that she was going to keep stalling it, taking it to trial, and taking it to trial, and taking it to trial. It just kept going for about probably close to 2 minutes.
Did you record any of that interaction? And did you have an opportunity to listen to that recording prior to taking the stand? Would you recognize it if you heard it again? Or if I can plug in and just play a second just for foundational purposes. Plug this in correctly.
And just so I'm clear, you were recording this?
I started to record it after probably about 30 seconds of.
Okay.
I realized I wasn't actually looking in the direction of Ms. Morgan or Devion, but I could see her turning back and looking at us, so I started to record it at that time.
Gotcha.
And what were you recording on, ma'am?
On my cell phone.
And I'm going to play again just the first second here of Morgan _ recording just for foundational purposes. Do I have that might help. So I just played about the first 4 seconds. Ma'am, do you recognize that audio?
If you could play a little bit more.
I'll turn it up a little because it's a little bit quiet. You recognize that audio? Is that the audio that you recorded today? And having listened to this, is this a fair and accurate copy of the recording that you made? Your Honor, for the purpose of the bond violation hearing, I move to admit what's been marked as People's Proposed Exhibit 1.
The objection of order. Exhibit 1's admitted.
Permission to publish, Your Honor?
Yes, sir.
Ma'am, other than that audio recording, have you had an opportunity to view any video recording from this incident? And can I put up People's Proposed Exhibit 2 for foundational purposes?
Yes.
All right, and pausing just on the start here. Ma'am, do you recognize this video? What is it?
It's the hallway outside of the courtroom.
All right. And how do you recognize this video? Do you see yourself in it anywhere?
So to the right, the far right, in the white jacket.
I don't know. My mouse does come up. Is this you right here?
That is, yes, correct.
All right. And have you watched this video before? And is this a fair and accurate reflection of what happened in the hallway? Your Honor, I move to admit what's marked as People's Proposed Exhibit 2 for the purpose of bond violation hearings.
Any objection of what here?
Permission to publish?
Yes.
And just for the record, this is about a 5-minute, 9-second long video. There is no audio on this one. I am pausing at the 30-second mark. Ma'am, do you see the defendant anywhere in the video at this point?
She's sitting on the bench to the left of the door to the courtroom.
I'm hovering my mouse over an individual. Is this the individual you're referring to? I'm going to continue from the 30-second. I'm going to pause it at 4 minutes, 30 seconds. The last 30-ish seconds, that informant, certainly if the court wants to play it, I can't.
Pardon?
I'm going to just pause it here.
That's fine.
Can we take me off, please? Thank you. Prior to the defendant making any comments to you, had you said anything to the defendant? Did you ever say anything to the defendant today? How did it make you feel when the defendant was saying these things to you?
Intimidated. I think that she was trying to intimidate me.
And just to clarify, ma'am, what is your understanding of why you were subpoenaed to testify or subpoenaed to be here today?
Because of identity theft, and I'm not sure of the exact charges, but what I believe were financial exploitation issues for a elderly, vulnerable adult.
And were you prepared to be a witness in that case? And were you prepared to testify today? If I can have 1 moment, please, Your Honor. Nothing else at this time. Thank you.
Cross-examination.
Just a few questions, ma'am. We just watched that interaction on, I believe, exhibit B or 2. Appeared to be roughly 5 minutes. Anytime during that interaction, did Miss Morgan say your name or otherwise address you personally?
I'm also known as a cranky, skanky ass cracker.
I'd asked the court to strike that from the record. I asked if she'd mentioned.
I think she answered your question.
At any point in time, did you observe Miss Morgan leave the bench that she was on and come towards your bench? And at any point in time, did you see Miss Morgan gesture either with her hands or otherwise towards you in any way? Okay. And what exactly did she do in order to gesture towards you?
So you can see on the video, I did not turn to look at this. I Can you clarify, Miss Morgan? Is that okay, Miss Morgan? I did not turn and look at Miss Morgan this way, but periodically I looked toward the window and I could see her gesturing toward, turning around and gesturing and moving.
Okay.
Right.
So towards this direction, but could you confirm whether it was towards you or down the hallway?
It was toward Diana and me.
Okay. Were you aware where her counsel was, myself, where I was positioned at this time during that 5-minute interaction?
Courtroom.
Okay. And at any point in time, did you see me head down that hallway?
I believe at one point, yes.
Okay. And so when you saw Miss Morgan gesture towards that way, how were you able to discern that she was pointing at you versus talking about her counsel?
I'll see you down the hallway.
Okay. And it's my understanding that there were a couple other women on her bench. Is that correct? And would you agree with me that at some point in time she was conversing with those other women? And it sounds like you were able to hear some of what they were talking about. Is that fair to say?
I'm assuming they were women based on the video, but I could not hear what they were saying.
Understood. But you could hear what Miss Morgan was saying. And so did you observe Miss Morgan interacting or otherwise conversing with these women? Okay. Were you able to hear Miss Morgan addressing any statements or making any statements towards those women? Okay. When you heard the statements that Miss Morgan were making, how would you know whether she was talking about her case to these women versus addressing them to you?
She was turning and facing me and turning her arm toward me.
And you were able to only observe that when you periodically looked at the window?
Tell that she was the way she was positioning, because turning around in the video that I'm looking down, but I could see the way she was turning around.
Okay. But when she was making the statements that you were able to hear and periodically see, could you confirm whether or not she was actually making those statements to the women that were on the bench with her?
Can I give you an example?
I'm just asking that.
If I turn and talk to this person over here, is there a way to know that I'm talking to you or to this person over here? So because she was turning and looking at me, I was just making the assumption based on the commentary and the threats about going after me.
Okay.
Trial and taking this to trial and threatening me to get an attorney, that the comments were being made to me.
Okay. So you were making the assumption that it was addressed to you because it was about this case.
Correct.
Okay. And do you know if Miss Morgan was ever instructed by the court or otherwise not to be on that bench out there?
I don't know if this witness would know the court's lawyers.
Were you aware of any court order that she wasn't allowed to sit in that area?
The objection is a lack of foundation for the question. Go ahead.
Okay. Did you ever hear anyone tell Miss Morgan that she's not allowed to sit there? Okay. And did you ever hear Miss Morgan address the other individual that was sitting next to you by name? And did you ever observe Miss Morgan get up from her bench and come and address that other individual? Okay. And outside of this interaction that was depicted on the video, is it your testimony today that Miss Morgan made any other statements directly to you? That's all I have.
Can you redirect?
No, Your Honor,
Just one question. Was that Miss Plummer that was seated next to you?
No, the woman sitting next to me was Diane, who's next to Detective Quinn.
Gotcha.
She was one of the witnesses that was testified today.
Hold on just one second. Gotcha. Okay. All right. All right. You may step down. Thank you, ma'am. Any additional witnesses?
No, Your Honor.
All right. Any witnesses for the defense?
No, Your Honor.
All right. Thank you. All right.
Your Honor, I would ask that the court find the defendant violated the conditions of her bond, namely the no contact, or I believe she's ordered not to have contact with Stephanie Sings. I believe she was also ordered not to have any new criminal conduct. I'm not sure if it was ordered. I believe at a regulation on the pre-trial release order, but typically there's condition not to have any assault, intimidating, threatening, or harassing behavior. If that is an order, it believes to be a violation of that order as well. The court saw a video and heard the recording of the defendant was making some pretty serious derogatory remarks avowed witnesses in this case, calling them bitches and hoes. The court saw, but you could see that the defendant was apparently looking at and making a conversation directly to these witnesses while they were in the hallway together. Certainly, whenever anyone comes to the court, I believe that there's an expectation that they be treated with dignity and respect, and that we should not be afraid to come to court or be harassed while at court. And I think that what the defendant has done is a clear violation of her bond. I would again ask the court find she has violated her bond for both bond.
Your Honor, we would certainly ask the court to consider continuing her bond. While I may take issue with the choice words that were played within that video, and certainly would agree that there should be a level of integrity and dignity with confines of this courthouse, I don't believe that it is a violation of her bond conditions to use those choice. Heard testimony today that would indicate that Miss Morgan intentionally directed those statements towards the witnesses as opposed to expressing her frustration.
Where then was she looking? Recording.
Hold on. I think that the video speaks for itself, that she definitely turned her head at some point in time towards that direction. But I think when you review the video in totality, she's positioned this way to talk to the two women next to her, talking about her case, expressing the frustrations that she has about the case. And while I think you heard that there was an assumption that those statements were directed towards these other individuals, and at no point in time did I see in the video my clients stand up or otherwise point at these two people or otherwise use their name to mention them. I mean, we know who the witnesses are. When she
put her hand out like this, what was that for?
Your Honor, when she puts out her hand like this, I'm assuming what she's saying is talking about the case, the whether it's me as her attorney, whether it's the judge, whether it's the witnesses, speaking about her case. She's saying that she disagrees with where the case is procedurally and how it's going. I think that if she had the intention of intimidating these witnesses at any point in time, she could have stood up and said something to them, turned around and pointed at them, used their names as she knew who the witnesses were. There was no intentional direction towards these two witnesses to try to intimidate them not to speak when we already knew that they were here to speak. And so if that was going to happen, Your Honor, it would have happened the last time that they were here in order to testify at the preliminary exam. She's shown up at every single hearing. These witnesses have been there before that 5-minute window. After that 5-minute window, there was clearly no nothing that would show or otherwise indicate that she's trying to intimidate them. They were here at the last hearing. Obviously, she knew that they would be here again. And at that point in time, without getting into it, but kind of getting into it, is that we had already decided that we're waiving the exam for moving forward. So any effort to intimidate and otherwise encourage the witness not to testify would have been moot, because we were waiving the exam and moving forward with the case up in circuit court. What we decided to do at that point in time remains to be seen. But for today's purposes, there was no effort to intimidate those witnesses because we had already made the decision to move forward, and there was not going to be an exam today.
So intimidation, if it were occurring, would only be for this limited date?
No, but I think when you're looking at the totality of the circumstances for today to determine from the video, from the recording, from the testimony you heard.
Counsel, you going to tell me that when I look at that video and that aerial view, that your client is facing in the direction of her sinks, and the words that are being spewed from her mouth aren't directed at her?
Well, I wasn't there myself, Your Honor. I can go off.
Counsel, don't play word games with me. You heard the recording.
Yes.
You see the posture of your client as she's sitting on the bench. And are you arguing before me that that was not intended at the two witnesses, inclusive of Ms. Sings, as they're sitting there?
No, I'm not trying to insult the intelligence of the court. You saw what I saw.
Thank you.
Speak for itself. So I'm not going to sit up here and say that. What I would indicate is that I think that my client's expressing a general frustration about her case, as opposed to utilizing those words to try to intimidate them not to testify. That's what I would indicate to the court.
Briefly, Your Honor, if it were just the language and the derogatory terms, I think maybe that argument might hold weight, but I think that consider that the defendant also stated after this is over, I'm going to get lawyers and come after you or something to that effect. I don't remember the exact language. I think that clearly shows.
Yeah, hold on a second. Tom, you've interrupted Mr. No, do not do it again. Otherwise, I don't have to deal with it. Oh. Go ahead, Mr. Cook.
Thank you, Your Honor. I believe that language clearly shows that intent that this is directed at these witnesses, and it clearly, as the court had the effect of making these witnesses feel afraid. I would again ask the court revoke bond.
With respect to that statement, my clients previously indicated to me when we listened to the recording and talked about that she's telling those two girls on the bench next to her that that's what she intends to do. And so while the court can certainly interpret it that those statements are directed towards them as a threat, she's saying that she made those assertions towards the people next to her, that that's what she wants to do as a matter of recourse for this case.
Court has heard the audio. The court has viewed the video in this case. I realize sometimes lawyers are put into circumstances where they certainly have to argue on behalf of their client, and I don't fault them for that. That's what lawyers do, inclusive of myself when I was a lawyer. And you can only hold. But when I listen to that recording, then I look at the defendant's posture, the way she's looking. There's a period of time where she's looking either straight ahead or toward the people that are sitting on the bench with her, which would have been to her right. But then intentionally is turning and looking in the direction of Miss Sinks and the other woman on the bench. That's when those statements are being made. You know what? You want to keep shaking your head? I'll wait. Because I got all day. Are you done shaking your head? You don't have to agree with a darn thing I'm saying. But I'll be darned if you're going to sit here and disrespect me in my courtroom like you did them in the hallway. That's not going to happen, ever. Am I under? But it was very clear that she's looking in the direction of Miss Sinks. Well, and making those, some of the parts of it just sort of god-awful statements with an attempt, clearly in this court's mind, to intimidate Miss Sinks and the other witness and to testify, so that we're real clear in terms of her bond conditions. She is not to have any direct or indirect contact with the following persons, and that includes Stephanie Sinks. That is condition S on the bond form. That is just clear. She's not to have contact. That is a very big, long hallway. The courtroom is a reasonably good size. The defendant could have come and sat in the courtroom at any given point in time. She knew who Miss Sinks was. She knew exactly who she was talking to in the hallway. She could have come, Miss Sinks wouldn't move. She could have come and sat in here. And that's her obligation, is to avoid contact with Miss Sinks, either directly or indirectly. She purposely did that. I think she did it. You know, when people come to court, whether it be a defendant, whether it be a victim in a case, whether it be a witness, they are not to be intimidated into doing whatever they're doing, whatever stage it's at. If Miss Sinks, just to address counsel's point, that while the decision may have been made to proceed in a particular direction, it isn't the issue of whether or not there was going to be testimony and whether or not it was the defendant's intent to stop Miss Sinks from testifying. That's not the issue. She's not to have any contact, direct or indirect, with Miss Sinks. If Miss Sinks decided to just come down to this courthouse and just sit in that hallway. I don't know why she would, but that's fine. If she just wanted to come down and sit in the hallway, this defendant has to remain out of contact with her. She didn't do that. In fact, she was attempting to try to, in my opinion, in looking at that and listening to the recording, she was attempting to try to engage Miss Sinks, to say those things, to intimidate Miss Sinks, not only for today, but I think in terms of further proceedings, because this case isn't over. That's the defendant's obligation. Miss Sinks is not under the jurisdiction of this court to do anything. This defendant is. The court, after listening and seeing all of that, having heard argument, is going to find that the defendant was involved in the yelling and inappropriate phrasing at protected parties to the case in the 14A1 hallway, and that the court does believe was an attempt to intimidate the witnesses. This behavior not tolerated today. It will never be tolerated in this courthouse. And so that we won't have a return of this at all, defendant's bond is hereby ordered revoked. Defendant is remanded to the Washtenaw County Jail.
That's it.
Yeah, that's a short day.
Well, wasn't that much of a short day. You were watching it live. It was a full day of craziness with Judge Simpson. It wasn't much better off with any of them. Judge Wiggins, Judge Hesselink, Judge Middleton, none of them. It was a crazy day. What can I say? And I found a lot of court cases. Look at this crazy guy back here on the couch, ladies and gentlemen. That's my cousin. Everybody say, hey, happy birthday to my cousin back there. He's visiting for a couple of days. Just want to say thank you to everybody for coming out and hanging out and chat, watching this video with us. I'm going to take off here real soon and go hang out with my buddy here on the couch. We're going to watch some sci-fi shows, maybe even watch some, I don't know, Ferris Bueller's Day Off, probably not. The dogs say thank you. I say thank you. The cat says whatever, like he always does. And I just want to say, hey, we're doing it again tomorrow. So get ready. I have a full day of court cases planned to watch, and we're going to see what happens. We're going to do this thing again, and we'll see what we have. And I have a lot of stuff on the cutting room floor for Saturday, so be prepared. The weekend review is already filling up. Stay aware. Stay safe. Be weather aware. Do what Mama says more than anything else. And while I'm chattering here, let me see if I can get these credits started. We got a lot of people to thank here, especially Rhonda, Felix, Kiernoff, Mama, Vermiticus, Becky, Jen, all you crazy people. I want to give some special shout outs to Chada Skadum, Marty Duvall, Dobby. Thank you all so very much for your contributions to the stream. It is because of viewers like you that we are able to do what we do. Thank you for those contributions, ladies and gentlemen. Thank you all for coming out and hanging out in the chat. Yeah, we got that Mystery Science Theater vibe around here. That's kind of what we're going for. I have to admit. It's definitely a big inspiration. Ladies and gentlemen, thank you so very much for being part of the stream tonight. I am your Lone Wolf Usul. I am your host for this little here get together. I'm your curator for this not Mystery Science Theater 3000 courtroom version of craziness that we have. Wolfbot is not online right now, so we are not redirecting anywhere. So go hang out in Discord with Ron. That's a cool idea. And I will be seeing you later. And I'll just say thank you all for one last time. I am your Lone Wolf Boostle, and I am out. Thank you, Crafty. Thank you, X25. Thank you, Magi. Terry Bosworth out there. Becky out there. Who are all these other crazy people in chat? Shados, Gadoom, Batboy is back. Bromiticus, Bob Smith, Marty, I know you're out there somewhere. Mama, Rhonda, thank you both very much. Y'all have a great night. Stephen, who could forget you? Never forget Steve. Never forget Stephen. Hold on. Never forget Stephen. Never forget. And maybe go watch some Ferris Bueller's Day Off or something. I don't know. I got nothing else here. Go away. Bye. Thank you, Dobby.